want to welcome you to our second webinar of our summer webinar series. My name is Andy Jimenez, and on behalf of the Aegis and the Florida Insurance Alliance team, I want to welcome you and thank you for attending our webinar today on governmental contracts. I want to give a special thanks to the FIA members, as well as the FIA board members that are joining us today. I also want to extend a warm welcome to the Florida Association of Special Districts, both the administrative team as well as the FASD membership. We truly value the relationship and partnership that we've had throughout all these years. And, I want to thank you for your support and the loyalty that you've shown to our program. We did open up this webinar, not just to the FIA membership or the FASD membership, but to any other local governmental entity in the state, even out of the state, even though some of the stuff we're going to be discussing is Florida specific. But anyone that could benefit from the content and information that we're going to be sharing today is welcome to join us today. And so for those of you that are not familiar with FIA, we are a governmental insurance trust that's organized under Florida Statute 624.4322. And since 2011, we have been providing property and casualty insurance, as well as other risk management services to over 1,200 local governmental entities in Florida. And this includes over 900 districts. And just given the size of our membership, our team spends a significant amount of time every week reviewing contracts, whether it's an underwriter reviewing a contract to get a better understanding of the exposure in order to rate it properly, or a loss control consultant reviewing a contract to provide some advice on the risk transfer piece. And definitely in claims, one of the first things that we ask for after a claim is copies of all contracts, because it's crucial for us to understand the contractual relationships that the district may have with other parties or vendors. We need to understand that in order to properly assess the liability exposure that the district may have, and also to put other parties in notice that could potentially have some skin on the game. So I'm not exaggerating when I say that on some weeks we may see 20 or 30 contracts. And this may sound a little weird, but my team actually truly enjoys reviewing these contracts, particularly enjoy reviewing well-written ones. And after you review a lot of contracts, you actually start to develop the ability to recognize the fingerprints of the attorneys that were involved in drafting that contract. Over time, you recognize the wording, the sequence of the sections. And what stood out to me over the last 8 years is that the common denominator with some of the best contracts that I reviewed originated from Jennifer Kilinski or somebody in her firm. Jennifer Kilinski is the founding partner of the Law Firm of Kilinski Wick. She serves as general counsel to many special districts, most, if not all, I hope, are FIA members. And Jennifer and I worked closely during the COVID pandemic, providing guidance to our membership and kind of helping them navigate through some of the conflicting guidance that was being issued by both the federal and state government, as well as helping our members decipher some of the executive orders that were issued by DeSantis during that time. So when we decided to do a webinar on contracts, we knew that Jennifer would be the perfect person to team up with. We reached out to her, and I'm grateful to that she agreed to join us today. She has a lot to go over, so I won't have time to go over her entire bio. But what I can tell you is that after the presentation, we are going to be sending you an email with her contact information, as well as a copy of the presentation and the link where you can access a recording of this webinar. So we'll go ahead and get started. I'm going to be monitoring the chat and the Q&A. But Jennifer, if you can take it from here.
Great. Thank you so much. We really enjoy and appreciate working with Andy and his team at FIA. It's sometimes unbelievable to think that your insurer is your champion and a friend, and we really appreciate collaborating with FIA, and I'm pleased to be here before you today to present what for some may be a dry topic, but for us is our daily bread, the common government contract provisions, specifically relating to service and maintenance contracts. So just a brief introduction for us. Like Andy said, founding partner of Kilinski Van Wyk. We launched our firm from Hopping Green and Sam's, which dissolved in 2021. We currently represent over 150 special districts, either pending or currently established across the state of Florida, have offices in Tallahassee, Metro Tampa, and Jacksonville. And we also serve as issuers counsel in conjunction with public financing transactions. So just a brief overview of where are we going today. This is meant to be a high-level overview of contract subjects, breaking down parts of each contract that I would typically call service or maintenance contract provisions into as digestible a form as possible. Every contract, of course, has its nuances, its business points, and its specific requirements. But some of what we'll cover today, we deem best practices in nearly every government contract situation. What I'm not really covering in any detail today are construction contracts or other form of procurement documents. Those have their own set of best practice standards associated with them, though many of these terms also show up in those contexts. So these are the general contract categories when we're referring to some of these parts and pieces today that we'd be covering. So these are, private entity performing contracts on your property, things like, landscape maintenance, pool maintenance, events, management contracts for maintaining your facilities, license agreements, and other facility use contracts that we come into contact with just about every day. And then management of government operations. It could be everything from restaurant and golf course to school associations. And then inspection services, inspecting your hard assets, those types of field management services that many governments have to engage in to provide that support service to the government. For those of you that did not have the pleasure of going to law school, or for those of you that maybe did but haven't been in Contracts 101 in a while, just keep in mind from a substantive perspective, there are key elements of every contract in order to make it a legally binding contract. And those are offer and acceptance. I've made an offer to somebody and the other party has accepted it. Consideration, and we do talk about this with some frequency, that if we're asking for additional scopes of services or being asked to pay additional money, there should be some value exchanged for those additional services. So that's consideration. Mutual intent. Both parties must intend to create a binding agreement. Legality. You can't contract for an impossibility or something that is inherently illegal and expect enforcement. And then capacity. Do the parties have the legal capacity to enter into and enforce the contract? So when you start drafting a contract for us, and we talk about this with our new lawyers all the time, virtually any services contract we have, we start with what we call the contract story. So why are we contracting for this particular service or material? And we try to do that in as plain language as possible. I always tell our lawyers to put their Uncle Joe hat on. Can Uncle Joe read this contract and clearly understand the intent behind it? We don't need to use fancy legalese. We don't need to use old English. Try to make it as clearly and concise a story as possible as to why this contract is being entered into. Oftentimes, the recitals have definitions and references to attachments. So you want to make sure that those defined terms are clearly defined and are consistently defined throughout. For example, oftentimes we have a definition of work or a definition of services or a definition of materials, but then sometimes we'll review a contract and we'll see that now services are called work or materials are called services, and it's very confusing as to what we're relating back to the substance of that contract. We also oftentimes in these recitals have attachments incorporated by reference. If you've done that, you want to make sure that the attachment doesn't conflict with the contract terms. Again, oftentimes we'll get a proposal, it's got terms and conditions that are not really government friendly or government appropriate. We want to make sure that if we attach that and incorporate it by reference, that we're not now making this confusing conflict between the attachment and the actual contract. So some things to think about in the whereas clauses. And again, every contract is nuanced, but this is a really important part of setting up the rest of the contract terms. Part two of the contract structure is a really important part. It's what I would consider more of the meat of the contract. The parties need to understand and have agreed to the scope of services before you start drafting a contract. It's important for the on-site team to partner with either the lawyer or the procurement manager or whoever's going to be responsible for developing that really specific scope to ensure that the proposal scope is exhaustive. Does it have any notable exclusions? Is it specific enough without being so specific that you could not fill in the gaps for the related services? Did the vendor promise something verbally, but then it's not in the writing? Does that need to be addressed? For contracts that may require or definitely require permits, articulating who's going to be responsible for pulling those permits. Are there plans or permits that need to be included as a reference so that the construction project or the project that's being contracted for is consistent with those plans and permits? Many of our maintenance contracts refer to a specific function at a specific location. Maybe we'll call it the field, or we'll call it, an amenity facility. But if there are multiple of those, or it's not clear where that needs to happen, attaching a map, especially to maintenance services contracts, has saved us a fair number of disputes. Where do I put in the landscaping? Where do I maintain the mulch? That map becomes very important. When should the work start? When should it be completed by? Do we have hard deadlines? And we talk a little bit about liquidated damages, which is a trade-off for sure in contracting. Liquidated damages is typically going to increase the cost of contracting, but if a deadline is really important to you or your project, you may want to consider a carrot and a stick to enforce it. These are areas where we'd also be thinking about damage and repairs to damage. So if somebody's going to be performing services on governmental property or near private property, is there a clear responsibility for repairing that damage and on a date certain? Oftentimes we'll say notify such and such client within 72 hours and commence repair of damage within a reasonable time period. Maybe it's 5 or 7 days, depending on the nature of the damage. Do we have a designated contract representative? Because despite having a lot of effort with on-site staff to develop a scope of services, oftentimes we can't possibly anticipate everything that may arise. And so do we have somebody that the contracting entity can contact and get good feedback if there are field changes or other clarifications that need to be made? Another tip that we often talk about with our new lawyers is when you read the contract after it's prepared, 5 years from now, without being in the trenches, if you will, and producing this document, is there a clear understanding of what the contract was for and what the roles and responsibilities are? And then we talked a little bit about this, the specifications for services, making sure that there is mutual assent on what is included specifically and what may be an additional change order after the fact. This part of the contract to us is absolutely takes the most time, takes the most attention to detail, and is really where if you're going to have a dispute, this is the provision of the contract that, in my experience, most often has the most recipes for potential disaster. So taking your time there is really important. When it comes to compensation, it may seem pretty straightforward. We've agreed on a price to perform the services. But how that compensation is paid is often a topic of much discussion. So are you negotiating for a lump sum? Is it a lump sum not to exceed based on some sort of unit prices? There's a number of contracts where there's installation services, and that schedule of values becomes very important to price your contract. Have you articulated the timing of the payment? Is it due at completion? or at material, is there a material deposit and then completion at, or payment at substantial or final completion? We never recommend, I should say never, very, very rarely recommend to a client that you pay the full amount of the contract upfront, even for installation services. It becomes extremely difficult to have any leverage to get money back in the event of default or a contractor not showing up. The timing of the payment also needs, for all of our governmental clients, to be consistent with Florida's Prompt Payment Act under Chapter 218. And remember that for Prompt Payment Act, there are different requirements for construction services and for non-construction services. We've had this issue come up with some frequency too on specifically requiring any additional services that would result in additional compensation to be agreed to by the parties in writing prior to commencing that service. Failure to do that can often lead to significant disagreements between the client contracting and the contractor. For those services being provided, particularly in the construction realm, reserving the right to require proof of payments and lien. So if I'm going to do a monthly installment or substantial completion installment payment, we're going to require that contractor to procure lien releases from him or herself, as well as his or her subcontractors. For the term and termination, we often, again, especially when we're talking about service or maintenance contracts, we would typically have a specific start date. Oftentimes for us, we're tying these to the fiscal year if we can. So even if we're contracting because we've had a change in vendor July 1st, we typically try to line that up with an October 1st renewal date. You may also be doing a notice to proceed. You want to get somebody under contract, but you're not quite ready to have them start. You want to be very specific about when the effective date is that contract is, so that all of the other terms and conditions can run from that date. There also may be a specific termination date. It may be a date certain. It may be project ending. It could also be, for cause or without cause. Many of our contracts, especially those that are publicly procured, have automatic renewal provisions. Keep in mind that Chapter 287 has specificity around how long your automatic renewals can be for. You also want to make sure that you know your own agency's rules for renewals. For example, most of our special district clients have a rule allowing up to 5-year contract terms so long as the contract is compliant with Chapter 287. On the general termination provision, we recommend to our clients to always give the government entity the ability to cancel for cause. It could be immediately for contracts that may be difficult to just abruptly cancel. We may have 30 days for cause with an opportunity to cure, or a convenience termination provision. So we've got elected officials. We know that at some point in the future, there may be a reevaluation of that particular contractor, or we may have some issues that are not quite material breaches, but that particular entity decides they really need to go a different direction. So we want to give them some flexibility. And the way that we will do a notice without cause is we typically contemplate what those services are. For something that's really difficult to shift in a 30-day period, we may have a 90 or 120-day notice with cause provision. So something to think about based on your own particular need. Oftentimes, reciprocal termination is a negotiated contract term. Again, a lot of that's going to depend on what types of services are being provided. And then thinking about the potential payment subject to claims and offsets. Again, we often have, if we're crosswise and we're terminating for cause or without cause, having the way that termination is going to happen built into your contract. What can you hold as set-offs? When is that final payment due? What kind of information does the contractor need to provide in order to get that final payment paid? It's much easier like any situation, to negotiate that while everybody's getting along than to try to figure that out on the back end. We, on our contracts, we always have a warranty and covenant provision. The content of that warranty and covenant provision is going to be very fact specific based on what you're contracting for. So we typically have something along the lines of the materials must be new. Yes, we have had situations where materials received were not new, and that can be a problem. So you learn from your own experiences. We always require assignment of manufacturer's warranty if it's applicable. I mean, plant material, you're not going to have a manufacturer's warranty, but if you've got playground equipment or something like that going on, having that assignable is very helpful. Then there's a question about whether the services are going to be warranted or if it's the materials. This is often a negotiated contract term, again, depending on the nature of that proposal and that particular scope of services. So something to think about. And then checking the proposal. This is an area with our experience that we often have heard the verbal representation, at a board meeting or through our on-site staff that says, oh yes, there's a 2-year warranty. But when you get to the proposal, it's not listed in there. So making sure that what you've warranted here, represented here, is not disconnected from the actual proposal that's being provided by that contractor. Now a subject that we could do, I'm sure, many seminars on, and something that I'm sure is near and dear to the FIA heart, is the insurance provisions that back up whatever contract that you're covering. So again, these are going to be very project specific, although I think some should be standard. Workers' compensation, commercial general liability, employer's liability, and auto liability we have in every single contract that we draft. Those are standard for us. The amount of coverage may differ depending on the risk of that particular contract, but those are pretty standard provisions for us. We then move to consider other risks. So if it's a construction contract, you may be thinking about chemicals and pollution. We have some contracts where our golf operator may store fertilizer, so we're thinking about what kind of instances could go wrong there. Do we have a designer? Is it an architect or an engineer? Do we have somebody on site that's handling governmental funds? Do we need to think about employee theft and dishonesty coverage? All of those risks that go into your scope of services are a direct extension of what kind of insurance you may want to consider obtaining for that particular contract. A subject, unfortunately, of much discussion the last couple years has been this abuse and molestation insurance. And those are, again, very fact specific. It doesn't have to show up in every contract, but these, for us, often show up in our highly amenitized special district client context where you've got adults spending time one-on-one or in small groups with minors, summer camps, swim lessons, tennis lessons, and the like. Unfortunately, after some of these large cases that most of us have heard about, the Boy Scouts cases, this came up and has been the subject of discussion. We recognize that insurance is very expensive, but obviously the risk associated with a claim is also very high. Another topic that we have collaborated with more times than Andy probably would like on some of our, again, highly amenitized clients is this alcohol rider for events and quantifying risk reward with bring your own beverages, a BYOB policy, large special events policies, resident, non-resident policies, that kind of thing when alcohol is involved. Not everybody takes the alcohol to the extreme, but again, when you have large groups with alcohol being consumed, the risk factor absolutely goes up. In all of our contracts, we also talk about additional insured status. So it's really important and very easy to forget that we spend all of this time negotiating these provisions. And then if we don't get the certificate of insurance afterwards, the number of times I have found when we audited our contracts that we never actually obtained insurance is pretty high. So you want to make sure that you close the loop on getting the COI in your files so that if anything happens, you have that at your ready. Our insurance provisions also have no cancellation without notice. Again, we've had that happen a couple times where we've had a claim and find out that the insurance was actually canceled. And now you're in a very bad spot with just a contract breach, but no insurance to cover it. We typically recommend a no subrogation clause that just prohibits the insurer from seeking reimbursement from a third party who may have caused the loss. And then if required to indemnify a private party, know that in certain circumstances, number one, you want to procure separate and adequate insurance, but even in the construction contract realm, the statute actually requires you to have the insurance to cover your indemnification provisions. My motto is when in doubt, consult with FIA. Again, we've had really wonderful collaborative experiences where we have a nuanced special event, a new issue that's come up where we've consulted with FIA on industry best practices on how to not have a deal, busted or really have this exhaustive insurance requirement for our contractors, but being able to clearly articulate to our clients the risk and reward of certain insurance coverages in certain high-risk events. I'm sure everybody can quickly digest this very busy slide, but the point of this slide is that every government contract that we draft has a sovereign immunity provision. Now, I've got the specific provisions here, which are hard to read, but unlike the that's just a bunch of words picture that you see in the corner there, it really isn't. It's really important protection afforded to units of government. And I'm sure most of you on this call have had claims barred as a result of this coverage. So just remember that Florida sovereign immunity refers to a legal doctrine that protects the state of Florida and its subdivisions, so all of our units of government, from being sued without their consent. And it's rooted in the principle that government cannot be sued for its actions unless it's explicitly waived this immunity. While a lot of our clients wish that it would bar contract breaches, alas, it does not. This has to do with liability for tort claims. But remember that you can also waive sovereign immunity if you're not careful. So definitely include that in every contract. Related to sovereign immunity, but in more specificity, this is the indemnification and limitation on liability claim cause. Again, a very highly negotiated clause in every contract that we've done through the years, but very important to the district and to limit liability for the district in the event of a claim. So first, typically we have an indemnify and hold harmless claim. Sometimes we have defend, indemnify, and hold harmless. A lot of that, again, is going to depend on the nature of the contract, the risk, reward, and what's negotiated between the parties. Generally, that indemnification is not limited to the amounts of insurance, but as I mentioned previously, there are special requirements in the case of construction contracts, and that's found in section 72506. Not going to go into a whole lot of detail there, but just know that if you're contracting for construction services, you need to be aware of that insurance requirement for indemnification. Otherwise, it could be rendered void. The case law on the indemnification clauses requires a level of specificity for an indemnity to be valid. So what does that mean? That means when you're drafting indemnification clauses, you want to be really careful about the broadness of those statements. What are you specifically asking the contractor to indemnify the district for? And what specifically may the district be indemnifying the contractor for? In all of our indemnification clauses, too, we include no waiver of sovereign immunity, again, because we want to be abundantly clear to the extent there may be some language out there in a proposal or an accidental conflicting provision later in the contract, that nothing in the agreement shall be deemed as a waiver of your client's sovereign immunity. The notices provision, pretty straightforward provision until you're in a termination or a lawsuit situation. But here you want to make sure that you've got the parties that need to, how parties need to be notified in the event of a termination, a default, or a claim. Are you okay with email? That's becoming a lot more commonplace now. And we have started adding to a lot of our contracts an email address with a required read or delivery receipt. Sometimes it needs to just be by mail. You want to make sure that if you change designees, if your client had a third-party contractor providing this type of service to them and it's changed, that you've given notice to your contracting entities to whom they should direct any legal notice going forward. Our general standard too is that we make sure counsel gets copied. We know that a lot of in our case, district managers are very busy. So if both people get copied and there is a claim, legal counsel is able to step in pretty quickly and start handling that particular situation. When it comes to provisions regarding default and dispute, again, just like any other context, it is a whole lot nicer to determine what's going to happen if the parties have a falling out in advance of that actually happening. We always recommend keeping all of these provisions together in one area. It makes the review of what exactly do I need to do here much easier, rather than it being in section 12 and then section 20 and then section 24. It also will help you make sure that those dispute resolution proceedings are consistent. I've reviewed contracts for sure that had binding arbitration, but then also a requirement that you first go to court. Remedies are important. Again, depending on the nature of the contract, the contractor with which you're working, you may consider binding arbitration. We've got binding arbitration clauses. You may consider immediately going to litigation. You need to think about venue. Typically, we're requiring venue to be where that particular project is. Do you have a prevailing party attorney's fees provision? And the specificity around the prevailing party attorney's fees. Is it for arbitration? Does it cover mediation? Does it cover, pre-suit demands? What are you actually able to recover in the event of a lawsuit? You want to avoid duplicate or conflicting language throughout the contract. Again, that's one that for whatever reason I've seen frequently. I think for a lot of us preparing these contracts, your eyes start to glaze over on some of these provisions because you're so used to seeing them that you may miss that particular contract has some conflicting information. And again, these are only used if people are in significant disagreement. So having that conflict becomes a real problem when you're trying to resolve a claim. And then generally just, know your audience and your risks. What is binding arbitration something that's actually digestible in this type of contractual situation? Or is litigation really the only way to likely resolve this dispute? Again, in just about every government contract, you have these additional governmental provisions that wouldn't show up in a private contract. So E-Verify, I'm sure all of you remember when that came out, that all the units of government had to comply with section 448.095 of the Florida statute. So we always just make a representation to our contractors that they're required to comply and conform to E-Verify requirements. The public records disclosure, a few years ago by statute that changed to a long version. So 119.07.01, where you designate the public agency and who that public records custodian is for purposes of handling public records, but also to make sure that the contractor knows what records they need to maintain, the length of time they need to maintain those records, and whose responsibility it is for turning over public records when requested by members of the public. Unfortunately, or fortunately, this comes up almost daily in our practice. For construction contracts or goods or services contracts that exceed certain thresholds, there are other requirements, and it seems like we do a lot of legislative tracking for our special district clients. It seems like these provisions change just about every year in terms of the depth of the scrutinized companies list, what needs to be disclosed there, the foreign influence, the public entity crimes. Just know that for contracts of these thresholds, $100,000 or more, $35,000 or more, $1 million or more, there needs to be a disclosure regarding a representation that you're not performing contractual duties with a scrutinized company or subjected to foreign influence. I would call this the everything else provision. Again, making sure that you don't have duplication here, making sure that it's very clear about what these representations are. And sometimes for small contracts, these are, we may remove some of these provisions just to keep the contract a little bit cleaner. But things like severability, so if one provision is found to be illegal, the rest would be held up. That this is an arm's length transaction, that there hasn't been some undue influence or only one party has negotiated the terms to the detriment of the other. Execution and counterparts is a big one with our contracts because usually the parties are in very different locations in the state. So having the ability for your client to sign one page and the other party to sign another and be able to put those together is an important provision. That both parties have represented that the party executing on behalf of that entity is authorized to execute. Again, something that's come up, I won't say frequently, but has absolutely come up where we've had an objection by a contractor that's in default that whoever signed that contract did not have the authorization to do it. If they've signed with that heading, we've got a good argument to say that they knew. Headings for convenience, again, pretty straightforward. Custom and usage, these are all pretty routine contract provisions. Successors and assigns and interest, not as much important for a governmental entity unless you anticipate you're assigning this to some other governmental entity, but certainly important for the contractors, the number of contractors that have been purchased or acquired or merged into other entities the last few years, especially in the post-COVID days, has been really pretty impressive. So we always have the successors and assigns that they agree that they're going to assume all obligations of that particular contractor is an important provision. Independent contractor status, depending on the type of contract that you're drafting, that can be a plus or a minus. Are they an arm of your client, of that governmental entity, or are they serving truly as an independent contractor? And really thinking about the roles and responsibilities of that particular contractor, especially in the management contract realm. And then representations that they're going to comply with all government regulation. If you're an engineer or you're a construction contractor, you know what your government regulations apply to your particular scope, and you agree that you're going to comply with everything that's applicable. So now you've drafted your whole contract, you're ready to get everybody signed. There are definitely some best practices here. And again, it's something that's easy to miss. You've done all the hard work in drafting all the substantive provisions. You've developed the scope of services. Now you want to make sure that you get signatures. So ideally, we're fitting those signatures all on one page if people are signing in person. Otherwise, we may do multiple pages. I do that a lot in our financings or our larger contracts where we're going to have the counterpart signatures just to keep it clean. We usually headline that signature page with, district signature or special district signature page. And then the next page may say, whatever, landscape maintenance contractor X signature page, so that if anything gets lost, we know exactly where those two things marry up. We typically have, signature, signing line, and a print name sign. We're coming more and more into practice of digital signatures. We definitely are encouraging that for the consultants that we work with to the extent legally you can do that. It's nice to have the electronic record and reminder of signatures because, again, we all are really busy. Depending on who's handling the signatures for your particular government, again, tracking people down to sign contracts can almost be a full-time job. So making sure that you followed up to ensure that the contract you worked hard on is signed is an important part of closing that loop. And with digital signatures, the nice thing for us, for our office, is that we get reminded on a periodic basis if the contractor or our client has not signed that contract yet. Again, these are just checklists, make sure that the party names are correct. Does the date need to be dated? Is the effective date of the contract as of signature? In which case you need to make sure that there is a date when it's signed, or is the effective date some date in the future, in which case you still may want a date, but it's not quite as important because the effective date is not as of the signature date. We generally, to help everybody get signatures, which can be a challenge, we don't usually have witnesses on the signature line unless it's required by law. So, recordable documents, real property transactions, license agreements where you're conveying some interest in real property, even for a short amount of time. You may need additional witness signatures. But for most of our contracts, one signature line makes it easy, and we're assured that we are actually going to get those contracts back in a timely basis. Again, we have to dot the I's and cross the T's because this is a pet peeve of ours. Frequently, again, you've worked really hard on drafting the contract. You've got all the signatures done. You have this excellent scope of services that your team, your on-site team, worked diligently to develop, and you get the signed contract back, and lo and behold, a year from now, there's a dispute on a breach of contract, and you pull the contracts that are signed, and lo and behold, it references all these exhibits, but the exhibits are not attached, and there's an argument that they never saw the exhibits, they meaning the breaching party. Best practice for sure is make sure as you get signatures done that that contract has included all correctly attached exhibits. I can't underscore that enough. It's been a huge challenge over the years, because a lot of times the meat and potatoes of what's being breached is in the exhibits. You want to make sure that there's consistency between the exhibit label and the text. Exhibit B is lined up with exhibit B, exhibit A is exhibit A, and the way that you've defined it in the contract makes sense based on the exhibit that's attached. Make sure that you can read it. I've seen legal descriptions that are in 6-point font. You will usually get rejected anyway, but it can make it very difficult down the road if you can't clearly see, if it's been scanned so many times in that you can't tell exactly what that exhibit is. We find that in maintenance contracts, you want it to be in color where you can actually see what area is supposed to be maintained. And then again, just so many agreements we find are missing the exhibit. So making sure those are right is really important. Then the last closing is sort of a recap of all those things that we said. Don't forget to get the final signed contract back. We've established a process to receive all those final contracts back. It is a heavy lift, but having a schedule of the contracts that have been sent out, sometimes our office is sending out 20, 30, 40 contracts a day, to make sure that they've come back signed and notarized correctly, recorded correctly if necessary, especially liens of record, is a really important part of the process. Again, you can have these beautifully written contracts, heavily negotiated, but if you don't do those final steps, which often takes a lot of time and a lot of energy, then you've done all of those things for naught. So having some process established with your governmental entity to ensure that you've got a good process to get those contracts back, exhibits attached, and your final record, so that when you're calling FIA because you've got a claim, you can send them a contract that's perfectly put together.
Perfect. Thank you, Jennifer. I think we got some time for questions. I'll start with a question regarding terms of termination. So, sometimes we find that a district will have a contract that had a specific termination date, yet the relationship continues past the termination date without any sort of update or amendment that would extend that contractual relationship. Can you talk about, what are some of the risks and how some of the disputes that may arise, when you're in this gray area? I mean, how would those be handled? Will the original contract still be what you referenced to address any of those issues?
Yeah, no, I mean, I think there's an argument that based on performance, you may be outside the contract terms if somebody has performed outside of that and you don't have a non-waiver provision. It definitely has come up before. This is kind of back to a best practice. If there is any change substantively to the scope of services, the term, the compensation, there needs to be a separate addendum. If a contractor notifies me that they're going to need another 30 days or 60 days or 90 days to perform that work, with or without a liquidated damages clause, my recommendation and what we try to articulate is some written addendum that the parties agree pursuant to the same terms and conditions as we previously negotiated. Now they have until whatever, 90 days to finish the project. And that may be the consideration question. Andy, if somebody wants an extra 90 days and there was no fault of my client, we may be discussing some reduction in compensation or some other consideration to make that addendum effective.
Okay, perfect. The other question, and I always find the public records part kind of interesting because sometimes you're dealing with a party or a vendor that may not have a lot of experience working with governmental entities, right? So, and private entities tend to be very private when it comes to their documentation and their records. So, if let's say, let's use the example of hiring an engineering firm, right? What sort of records that they are retaining would be subject to public records requests, and what would be considered work product or be excluded from the public records requests?
Yeah, it is something that comes up, I wouldn't say frequently, but with some frequency on some of our projects that again are, 30,000 resident special districts, for example, where we get records requests for pretty sensitive data like employment data. Our view on the law is that if there is a record that goes directly to the contract, so I've contracted with the engineer to provide engineering drawings for phase 1 of, district improvements, and somebody's asked for the work product that corresponds to that, at some point the district owns that work product. So those become public records. Same with the invoices that go to support the bills that have been submitted to that unit of government for use of payment with public funds. So oftentimes our contracts have very explicit accounting record requirements, and that the district has the right to request supporting documentation to address concerns or questions around invoicing irregularities. So our view, and it does come up, especially in the employment realm. Best example I can give is that we've got on-site management that employs 100 employees on behalf of the district to do all kinds of governmental functions, and we've got challenges in the way that that's being billed. So hours worked, time recorded, all of those things become public records when it supports an invoice for governmental funds to pay those invoices. But a lot of it is really fact specific.
Okay, question. So the other thing was, you brought up the independent contractor status, and kind of tying that into the sovereign immunity portion that you talked about. One thing that I think is important to keep in mind is that not just the district, but its employees and the board members enjoy sovereign immunity protection. And when you assign someone as an agent, the agents of the district also, by the statute, enjoy sovereign immunity protection. So sometimes if you don't have, if your intent is to have an independent contractor and transfer the risk of whatever responsibilities they have, whatever you're paying them for, over to them. So if there's any sort of claim made against the district that arises out of the negligence of that vendor, you should be able to go to the contract and be able to tender that claim to the vendor. The party that's responsible should be the party that steps up and pays the claim and provides a defense for the district and identifies the district. But if they are an agent, the argument can be made that as an agent, they're working on behalf of the district and under the direction of the board. So therefore, it would be the district that would be responsible. And if you assign someone as an agent and then you still have indemnification language in there and insurance requirements, those are kind of at that point don't even really come into play, because now they're an agent and they're working on behalf and under the direction of the district. That's something to keep in mind when the intent is to have an independent contractor relationship. Also, you don't kind of related to that is the employee-employer relationship. You don't want to have a contract that potentially establishes an employee-employee relationships, because then what that would create for you would be potentially an employment practices liability exposure. So that's something else to kind of keep in mind, that you want to make sure that that relationship is defined in that contract as well. See if we have any other questions. I think we are good. So, Jennifer, again, I appreciate it. Extremely informative. Thanks again for your partnership. And thanks everyone for joining us. As I mentioned in the beginning, we're going to be sending you an email with Jennifer's contact information. It's also on the screen right now. And once it's available, probably later today or tomorrow, we're also going to include a link to our YouTube channel where you can see this presentation as well, since it's been recorded. So thank you, everybody, for joining. Again, thank you, Jennifer, for preparing this for our membership. Thanks.
Thank you.